for a loan oft loses both itself and friend. This quote from Shakespeare's play Hamlet advises us not to lend or borrow money from a friend, because if you do so, you'll lose both your friend and your money. So how do Shakespeare's words apply to human resource professionals? It's cautionary advice for organizations who allow employees to borrow against future vacation or PTO accruals. This policy of advancing vacation time appeals to your new employees who haven't worked long enough to accrue time off. And it helps long-term employees who may have had to use their leave under special circumstances. According to our last paid time off survey, 25% of responding organizations allow employees to borrow vacation time. And you may treat this as a casual request, considering the practice a no-cost benefit or an exception to policy. After all, you can recover this loan by deducting the advance from the employee's final paycheck, right? Not so fast. A common problem arises when the employee leaves your employment before paying back the unearned time off. And just like other wage issues, both federal and state statutes have something to say about this practice. An opinion letter issued by the U.S. Department of Labor says employers can deduct advanced vacation time from an employee's final paycheck, as long as the employee is advised in advance. Although such a deduction may be permissible under the Fair Labor Standards Act, it's also important for employers to be aware that many state laws do not allow deductions from paychecks without prior written authorization from the employee. Colorado is one such state, and additionally, Colorado state law restricts employers from making any deduction that will take an employee below federal minimum wage. How to get around this? Payroll deduction authorization agreements are useful to satisfy the legal obligation before you make the deduction from an employee's final check. The agreement must be enforceable and not in violation of law. Sample authorizations are available in our FYI library, and these consider appropriate at-will language and include space for the employee's signature and date. You might want to consider executing a promissory note with the employee just in case the amount to be recovered cannot be satisfied by the employee's final check. This is general guidance that applies to most Colorado employers, but organizations with multi-state operations should contact an employer's council attorney to determine the appropriate standards in other states.